Hey there, everyone. Ronnie Carnick here. It's 2020, and most companies use tech. This comes as no surprise to you folks. Even if you are in a remote village somewhere with an Etsy store, you've probably executed a SaaS agreement, a software as a service, click wrap contract of some kind for using whatever software platform you are using. Software can be in an operating program that you download to your device, your computer, or it can be a remotely hosted application, right? Something that's available via the internet. So I hope that today's video helps some of the, especially is particularly geared towards practitioners in this space, legal practitioners. It's not intended to be any kind of legal advice. Please consult your independent legal advisors for legal advice. Okay, this is a practitioner to practitioner video. It's a non-exhaustive list of the kinds of things that you should look for when negotiating a SaaS agreement on behalf of your client, or suggested items that you look for and keep in mind. In more complex scenarios, other than the click wrap contract, certain provisions of the SaaS agreement are heavily negotiated. There are very bespoke SaaS agreements for any number of contexts, right? We're in the big data age where management of data is paramount. So we're coming up with new ways to manage and access that data. And our software developers are helping us in this goal. So first couple things is, I would say, when proceeding to represent a SaaS client, is know your client. Now, this should be obvious, but it's something that I think in doing your proper diligence of your client, it's really getting an understanding of the kind of business that they're doing and what they're doing, what kind of data they're dealing with specifically. Because when you're dealing with a financial institution, you may be subject to OCC, Office of the Comptroller of the Currency regulations or guidelines that deal with the technology providers, third-party vendors and technology providers that provide services when you're dealing with, financial data of customers. So, you have very specific provisions dealing with financial data of customers as well as with money, and you're going to be integrating those kinds of guidelines. Similarly, are you a covered entity that might trigger HIPAA? And you're going to need to ensure that your agreement jives with the HIPAA regulations, for lack of a better word. You want to be in alignment with any applicable state, local, federal, even international law, depending on where you're doing business, where the data is being stored, and consult your advisors in the jurisdictions as needed to make sure that is, and consult your subject matter experts to ensure that that data is being protected properly. Second to knowing your client is know your client, but probably paramount when it comes to the contract is to know your client's objectives. So this is vital for the client, for managing expectations, and really on both sides. What is your client seeking to do? And what are the technical specifications of this software that are going to be needed in order for it to have the intended functionality? You want to delineate as clearly as possible what that is for both sides, what kind of data needs to be delivered and when by the client, and how this software is going to get rolled out and delivered. You're going to want to understand what the warranties are for unavailability of the service if there's a delay in the rollout, or they come upon some sort of issues, how those will be communicated, what will be the client's responsibilities at that time, and what are their rights, if the system goes down. We'll get to indemnification and breach later. We also want to talk about the data itself, in terms of, who owns it. How will it be converted? What's the transition plan? It may not go into every single tiny minutia of what that plan is going to be, but at a very understandable level and coherent level, you're going to need to understand what happens to the data, who owns the data, what the software provider is going to do with that data, especially if it's sensitive, right? Are there legacy systems involved? How it's going to be, how it's going to reach its destination, and will it be destroyed at the end of that migration? Will there be a period where that data will exist, and how will it be secured while this integration process is happening, right? So you don't want to kind of import all the data and expunge it, and then the program doesn't work the way you need it to, and we can't get that data back. That creates a huge amount of business risk, depending on the context, right? Or, conversely, you don't want this data hanging around and even being profited on if you don't know about it necessarily, right? So if it's okay for them to share that data or use that data in some way, let's put some parameters around it that make sense and are in adherence with the regulations, as well as industry best practices. And most of all, what our client would like to see, right? So any good contract that I've seen is going to have indemnification, liability, what happens in the event of breach. You hope not to ever need this kind of stuff, right? This is more standard contract stuff. But, those are some of the things that you want to clarify when you proceed on this exciting endeavor of negotiating SaaS agreements. Again, please consult your independent legal advisors for legal advice. And thank you for checking out this video, and I hope you'll subscribe to more like it in the tech and law space. So thank you.